Emergency Protection Orders. An Emergency Protection Order, EPO, is an urgent order granted by the court if a local authority thinks that a child is in immediate need of protection from, or at immediate risk of, significant harm. If an EPO is granted by the court, a local authority or child services share parental responsibility for the child, and in support of their application, they will have filed a proposed care plan. A care plan will outline their views on whether the child should be removed from the parents, and if so, where they should be placed. This will also include details on safeguards that need to be put in place to address the identified risks to the child, and what contact can be safely arranged for the parents to see the child. You may commit a criminal offence if you try to prevent a child from being removed once an EPO has been made. The child is usually removed by a social worker and can be accompanied by police if it's felt necessary. How long does an EPO last? An EPO usually lasts for up to 8 days. However, an application may be made to extend it, although this is unusual, as care proceedings would usually be started during that time. What contact can I have with my child if an EPO is made? The local authority is under a duty to allow reasonable contact between the child and their parents. However, what is reasonable depends entirely on the circumstances of the case, and most often any contact that is permitted by the local authority is supervised. Can I appeal against an EPO? You can apply to discharge the EPO within 72 hours if you were not given notice of the hearing or were not present at it. However, if social services believe the child to be at risk of harm or immediate danger, they have the right to apply for an EPO without giving notice to the parents. Following an EPO application, the local authority will usually apply for an interim care order to maintain the child's arrangement, pending further assessments and investigations into the family. Parents are given notice of any interim care order applications listed before the family court, and legal aid is available, as it is not means or merits tested. It's at that first hearing that the parents may wish to challenge the continuing separation from their child, and the ICO hearing may be listed sooner than any appeal can be prepared. How we can help. Our expert team of family solicitors are specialists in emergency protection order and interim care order applications, and are experienced in responding quickly in what is almost always a very rapidly developing situation. Contact National Legal Service for a free initial consultation today.